Hey everybody, how's it going? Hope you're having a lovely day. Today we're going to be reviewing the dark history behind the DMCA. The DMCA is otherwise known as the Digital Millennium Copyright Act. It's a law that passed in 1998 that makes it illegal to break a digital lock or circumvent a technical protection measure to gain access to a protected work, even if that protected work is something you bought and paid for. An example of this would be the Echelon exercise bike. This is an exercise bike that was sold as allowing you to connect to third-party applications. You were able to do that at the time of sale. They sent out a firmware update to this bike that no longer allowed you to do that. Somebody came out with a way to get around this, that you could use other third-party apps that don't have subscriptions and everything in them on the exercise bike that you bought and paid for. And that person can't release it because if he does, he could go to prison for 3 to 5 years. Lexmark makes printers, but as many printer manufacturers do, they would like that you buy their ink. They tried making printers that only work with Lexmark ink, and when somebody else came out with a way to make it work with third-party ink and started manufacturing ink, they took them to court and sued them. The DMCA is the reason that a company like Bamboo Labs can try and drag someone like Powell into court for taking AGPL code, forking it, and allowing people to be able to connect to their printers the way that they were before the manufacturer sent out an update that changed everything. The man that architected, lobbied, and pushed this law through for many years came out and admitted that it was horrible, which leads me to the question of why has there been no reform over the past 30 years? Bruce Lehman is a former corporate copyright attorney turned government official who worked in the Clinton administration. He was the primary architect of this bill. He wrote a 263-page white paper that served as the basis for what eventually came the Digital Millennium Copyright Act. I'm going to play you a clip from Bruce Lehman.
Unfortunately, at least in some areas, our policies haven't worked out too well. Our attempts at copyright control, at least thus far, have not been successful. But I don't just blame teenagers and college students. I really blame the moguls in the music industry, because had they been thinking about these business models when we were doing our work in 1994 in the Clinton administration, had they been developing effective online distribution models when the internet first came into business, had they been talking to Steve Case when AOL first started to become a big deal, and really seriously developing an online business model, perhaps we would not be in the situation that we are. But the culture of that industry was such that, those people were concerned principally with, and their talents were developing talent, understanding public taste. They didn't know anything about distribution or technology or anything like that. Minions dealt with that. Well, their industry has paid the price. Hopefully there's not any, I won't be quoted in the U.S., but I'm afraid our Clinton administration policies didn't work out very well.
You could tell that even he knows that he fucked up based on how he was talking, because halfway through the clip, he just goes and takes a pause for a second, and then he makes that mouth noise again right before putting the blame where it belongs, not on the college students and kids and teenagers that were downloading things. He was putting it in the lap of the music and movie industry that failed to adapt. It's 2026, and if I want to take my 4K Blu-ray and I want to be able to watch that on the phone on a plane, I can't do that. I'm not allowed to do that. That is technically illegal. I have to get some sort of streaming service. I have to buy media with DRM that's going to be infinitely lower quality than what I already have. So I use my beautiful little BDR 2213 with old firmware, and I rip a nice, beautiful 4K uncompressed copy that I could watch on my phone anytime that I want. When you hear that sigh and him go, it has the energy of, I fucked up, but I won't admit it. I had a technician that worked here about 10 years ago, God rest his soul. His name was Milan. He was amazing at what he did. He was doing a very difficult repair on camera, and he wasn't really used to being on camera. So he messed something up, and this is what it looked like.
You can put that back. Fuck. Okay, you fucked up. So now you need to take the screen out. This is when it gets fun.
You feel that, don't you? Right through the screen. But the difference between Milan, who had integrity, and Bruce Lehman is that Milan says, we fucked up. He's honest about it. What bothers me so much about this gentleman is that he realizes that he had a big part in architecting one of the worst laws for technology in the United States and across the world, and he does absolutely nothing to actually fix this with all the knowledge, the connections, and everything that he has. But it actually gets worse. He brags about the fact that this law got passed even though Congress didn't want it passed. Listen to this.
That is where the anti-circumvention provisions came in, because we felt that we needed to make it an infringement to attempt to disable the box in an unauthorized manner, open the electronic package that the copyright owner had put their work in. That was one of the major provisions of the act, and probably the most important one. That really is what we sent up to Capitol Hill. Concurrent with this process, we were also engaged in negotiations at Geneva the context of the World Intellectual Property Organization. And we took two long-time treaty negotiations that were really about old-timey principles in the international copyright law, and we turned them into a treaty negotiation over, they were called the Berne Protocol, Phonograms Protocol, something like that, those two projects. We converted them into a diplomatic discussion of what should the international law of the internet look like. And there we had this problem in that the laws of most of our trading partners, and particularly the traditional European countries, who had been the countries that gave rise to the Berne Convention, which we were then a part of, those countries did not really recognize this broader distribution right. One of the most important aspects in the treaties that then emerged in 1976, finally, when we concluded our negotiations in Geneva, was that in addition to these anti-circumvention provisions, we had in the treaties we had a right of making available to the public, so that we gave copyright a much broader footprint, that literally it's now an exclusive right under the WIPO Copyright Treaty and WIPO Phonograms Treaty. That those are the two, what the treaties were finally called, and they're adhered to by most countries, although not, there are a few significant exceptions. Now you have a right in all those countries to make available your work to the public. That's an exclusive right that you have. We felt we didn't need to make any changes in our law. Now, a lot of people accused me at the time of doing an end run around Congress and everybody else by negotiating these treaties and then coming back and saying, well, we have, because we submitted this to Congress before the treaties process was completed, then coming back and saying, well, now you have to do this, Congress, because we've agreed to a treaty. And I would say that they're probably right, that it was an end run and it was partly deliberate. But I think we had both a international and a domestic problem. You cannot separate. The internet doesn't know national boundaries. Obviously, that's a major problem for us today. The DMCA really was legislation implementing an international treaty obligation.
Unbelievable. So he writes a paper in 1994. He tries to get a bill passed 1995 and 1996. Congress says, no, we want nothing to do with this. So what does he do? Does he give up and figure, I guess the American people don't want more restrictions on their computers? Or does he say, I'm going to try to fly away to another country and sneak this into an international treaty to force Congress to pass this bill? This is kind of like if your girlfriend comes home and says, by the way, honey, I cheated on you with somebody else and now I'm pregnant. You're going to have to take care of the kid. That's what he did to Congress. What the fuck? And the thing that gets me is that 1998, the law passes. In 2007, he admits the law doesn't work. In 2013, he admits that not only did the law not work or do what it was supposed to do, but he got it passed in a corrupt way and he did it intentionally. And it's still a law. I think they call this failing upwards. It actually does get funnier.
One of the points I want to make is that the image I just had on with the bill that's at the very back, the 12-page bill that's at the very back of the white paper, became this statute, which is over 60 pages long. And actually, the printing is smaller and the lines are closer together, too. So this is what happens when a proposal that anybody makes, and especially an administration makes, goes to Capitol Hill and then the lobbyists get a hold of it. And what you find, once something looks like it's really going to happen, obviously the interest groups have to get involved. They hire armies of lawyers and lobbyists. And the final statute that comes out, was a guy who was the head of then the biggest record company in the world, Warner Records, and he was a very nice guy, and he wrote a book a few years later after he retired and confirmed what I always thought to be the case about record industry executives. Record industry executives are impresarios, and the most successful record industry executives I would characterize as a 45-year-old man who can think like a 17-year-old girl and likes to hang out at 3 o'clock in the morning and do drugs with rock stars. And he basically admitted to all of that in his book that he wrote several years later. Unfortunately, that is not a mindset, a part of the brain that does very well at evolving new business models for highly complex technologies.
He's essentially saying that the people that are coming up with these are man-child drug addicts and that they should not be allowed to actually come up with laws. They're bad at figuring out business models when it comes to technology, that they shouldn't be regulating technology, that they're man-children and junkies, but I helped them regulate technology. And it didn't work right. And we tricked Congress into doing it. And the law is still here. I'm actually starting to feel a little bit bad about myself. The person who architected this law admitted that it sucked, admitted that it didn't work, admitted that it was a bad idea. He admitted that he skirted the democratic process in an unethical way, maybe illegal, but at least at very least unethical way, admits that the people that made the law are essentially man-child junkies that shouldn't be regulating technology, but he helped them do it. And 13 years later, it's still here. It should be easier to repeal this law than it is to repeal laws about burning witches. He admits what Gabe Newell has been saying for years, that piracy is not a pricing problem, it is a service problem. If only the movie and music industries that actually work with technology companies and consumers to come up with better business models in the early days, you wouldn't need this. It didn't accomplish what he set out to accomplish at all. And above all, he's like, yeah, hopefully I don't get quoted on this. Oh, you are getting quoted on this, sir. Entertainment companies wanted stronger laws to protect their CDs and software from being copied. Bruce Lehman got appointed to run the U.S. Patent Office under Clinton. They were frustrated that the previous models could easily be cracked, and sometimes these were even getting cracked by teenagers. From 1983 to 1993, Lehman was a partner at the Washington, D.C. law firm of Swidler and Berlin, which is very tempting to pronounce as Swindler and Berlin, where he represented individuals, companies, and trade associations in intellectual property rights. His major clients come from motion picture and broadcasting industries. In the early 90s, President Clinton appointed Bruce Lehman as the Assistant Secretary of Commerce and Commissioner of Patents and Trademarks. In 1995, Lehman's group published a 263-page document called the whitepaper, officially titled Intellectual Property and the National Information Infrastructure. It sought to expand and strengthen the copyright protections and anti-circumvention rules beyond what many consider their original intended scope. So it's going to do the following things. Number one, it bans the tools. The whitepaper would make it illegal to, and I quote, import, manufacture, or distribute any device, the primary purpose or effect of which is to circumvent a digital lock, and it would only prohibit the manufacture of circumvention devices. Here's what they didn't do. They did not ban you from opening the lock. They only banned people from making and sharing the key. The part where it becomes a crime to crack the lock yourself is what happened 3 years later in the DMCA. Secondly, it turns reading into copying. When a work is placed into a computer in RAM for more than a very brief period, a copy is made. So to Bruce Lehman, loading a file, opening a page, or just looking at the thing on your own screen, all of it makes a copy they get to control. So they're defining reading as copying. The third thing that they wanted to do with this, which I think is just insane propaganda, is take it to public schools, even as early as elementary school. The paper talks about a copyright awareness campaign and says that copyright education should not be a series of thou shalt nots. Instead, it says education should carry a just say yes message, that works may be accessed and used, and that seeking permission is not an insurmountable barrier. It wants core concepts introduced at the elementary school level, teaching kids electronic citizenship, and it wants model curricula that could then be disseminated to state school boards, private schools, libraries, community centers, and other educational institutions. This part is absolutely fucking diabolical. For example, the concepts of property and ownership are easily explained to children because they can relate to the underlying notions of property. What is mine versus what is not mine, just as they do for a jacket, a ball, or a pencil. At the same time that children learn basic civics, such as asking permission to use somebody else's pencil, they should also learn that works in a computer system may also be property that belongs to somebody else. Therefore, they should learn what one participant refers to as electronic citizenship, including how to determine the owner of a work and how to go about asking for permission to use it. This is the law that is used and cited when the 3D printer company says that the printer that I paid $1,000 or $2,000 for has to connect to their fucking server before I could print something. This is the law that is used when the exercise bike that I purchased stops working with the application that I was using it with because you sent out a fucking firmware update. This is the law that gets cited when a company makes a fucking thermostat into a subscription because they weren't making enough money. The entire point of this fucking law is to say that we don't own anything. It's not to protect the copyright holder. It's to say that the product that you have been sold is not yours. This Blu-ray over here, if I want to take this fucking show that I bought and paid for, and I want to be able to watch it on my portable media player instead of carrying around optical media, I'm not allowed to do that because this still belongs to the fucking person who sold it to me. They're not only trying to tell you that you don't own anything, they're trying to get kids at the fucking kindergarten level to believe that what is on their computer is not theirs. This law wasn't just about restricting what's being done on your computers, it was about getting the next generation to be okay with it via propaganda that they start disseminating in kindergarten. You know what the difference is between a jacket, a ball, or a pencil, or any of these things that Section 12.1 of the DMCA applies to? None of those things are things that the manufacturer can tell you how you can use after the sale. None of those items have restriction. My ball does not say that I'm not allowed to play with it after 7 p.m. My pen doesn't tell me what I should write. My jacket doesn't tell me when I'm allowed to wear it. But items that Section 12.1 of the DMCA apply to? Oh, they tell you exactly how you could use it. I'm allowed to put this Blu-ray into a Blu-ray player or a Blu-ray ripper that can rip up to 1080p, but not 4K because there's extra encryption, and you're not allowed to use that in this drive because if you... No! You're making a bullshit comparison. And I think the funny part here is that when they wrote this stupid law, none of this existed. This wasn't a problem yet. Because when you bought something, you could just fucking use it. None of this stuff was ever considered or conceived to be a business model. None of this was ever a problem. Nobody had conceived of a world where we own nothing. which is where we are now. Everything he's bringing up is something under the old model of ownership, not the new models of ownership. Your ball does not tell you that you're not allowed to play with it after 7:30 unless you pay for a fucking extra subscription. Your pen doesn't stop writing even if there's ink in it unless you pay them an additional fee a month, and your jacket does not stop working below 20 degrees unless you pay them more. This is a bullshit comparison because they're trying to compare items where you have actual, real, genuine ownership with the modern world, what this law brought into place, a world where you have no ownership. Not only do they want to gaslight normal people, they wanted to gaslight the next generation. Nice try, asshole. This fuck didn't just want a law, they wanted propaganda in kids' schools from fucking kindergarten, learning that if you rip a Blu-ray so that you could watch it on your phone instead of just watching it on a portable Blu-ray player, that you have committed a crime. A law professor named Jessica Litman watched this mess and gave it a better name: just say yes to licensing. In a spectrum of possible strategies, the solution suggested by the white paper is at one extreme. Let's first interpret the current statute to define as an actionable copy every appearance of a work in the temporary memory of any computer anywhere. Then let's make the good old rules as interpreted apply with full force to those 10 or 20 million new printers, reprinters, publishers, and vendors, essentially by fiat. We'll simply say it does, and then we'll try to ensure that they see it that way by teaching them to just say yes in elementary school, by encouraging the widespread use of technological controls that compel them to comply with whatever terms copyright holders elect to impose, and by pursuing a subtle but decided shift towards criminal enforcement of extant copyright rules. She wrote that in 1997. Very ahead of her time. Shout out to Jessica Litman, that is awesome. Bruce Lehman's paper was torn apart at the time. It was not well received at all. Legal scholars like law professor Pamela Samuelson criticized the white paper from the beginning. Her January 1996 Wired article, The Copyright Grab, criticized the proposal as an erosion of fair use. Browsing through a borrowed book, lending a magazine to a friend, copying a news article for your files, all seem innocuous enough. But the Clinton administration plans to make such activities illegal for works distributed via digital networks. If legislation recommended in its white paper, Intellectual Property in the National Information Infrastructure, is enacted, your traditional user rights to browse, share, or make private non-commercial copies of copyrighted works will be rescinded. Not only that, your online service provider will be forced to snoop through your files, ready to cut you off and turn you in if it finds any unlicensed material there. The white paper regards digital technology as so threatening to the future of the publishing industry that the public must be stripped of all the rights copyright law has long recognized, including the rights of privacy. Vice President Al Gore has promised that the National Information Infrastructure will dramatically enhance public access to information. Now we find out if that will be available only on a pay-per-use basis. This article was written by Pamela Samuelson in 1996. It has been 30 years, and she was completely right. Now, you may think that, well, sucks, Congress is going to pass laws people don't like anyway. But that's not true. Congress actually looked at this steaming pile of shit and said no. The white paper got turned into a bill called the NII Copyright Protection Act of 1995. Congress looked at this and basically said this is way too extreme. They refused to pass it, which is the normal democratic process working as intended. A lobbyist or a person working for the administration says, here's a horrible law that the movie and the music industry want passed. Congress looks at this and says, fuck no, the people in my district are going to kill me if I pass this. The Copyright Office's annual report for the fiscal year 1996 states clearly that the 104th Congress adjourned without enacting either bill. The two bills, Senate Bill 1284, introduced by Senator Orrin Hatch with Patrick Leahy, and the identical House Bill 2441 from Carlos Moorhead with Representative Pat Schroeder, never even got reported out of the committee. This bill never even got to get put for a vote. It just never made it out of committee. It was seen as a joke. Even the government's own copyright chief had a problem with this. The Register of Copyrights, Mary Beth Peters, testifying before the House Subcommittee on Courts and Intellectual Property in November 15, 1995, called the anti-circumvention provision somewhat overbroad, warned that the uncertainties involved in the provision as drafted may chill developing markets, and recommended that the language be narrowed. Representative Rick Boucher and Tom Campbell in the House and Senator John Ashcroft in the Senate introduced rival bills to protect fair use, shield internet providers, and narrow the anti-circumvention rules. This bill was written because they wanted to undo something that was horrible that was about to happen. Rick Boucher was an absolute pioneer when it came to freedom. I still remember reading about him when I used to read boycottriia.com back in the year 2000. He was a real champion when it came to fair use. He said that the RIAA's response, the Recording Industry Association of America, does little to relieve my concern that consumer fair use protections are being threatened by what we now see as the intended widespread introduction into the U.S. of copy-protected CDs. He warns that copy-protected CDs threaten consumers' fair use right to copy their own discs, which I agree with. I have a Pioneer BDR 2213 over here that for the last damn near 10 years has allowed me to make copies of 4K Blu-rays for myself. I can take the copy, I could put it on my phone, I could put it on another computer, I could put it on my home theater PC. I don't care that there is copy protection on this. It's mine. Why should I not be able to watch it on my phone? Why should I not be able to watch it on my TV the way that I choose? That's ridiculous. I'm not going to buy a portable Blu-ray player instead of just put the fucking thing on my phone. Rick Boucher believed in fair use, and he was very much against this. Congress was very against this. So how did this law get passed if all of Congress was against it, if it never even made it out of committee? Well, let's go back to Mr. Bruce Lehman of the law firm Swindler in Berlin. In 1996, Lehman went to Geneva, Switzerland to an international organization called the World Intellectual Property Organization. He used his capacity as a U.S. delegate to craft a treaty. With very little public attention and oversight, he got the anti-circumvention rules written into international copyright treaties. After going around the back of Congress and the American people to other countries to try and trick them into getting this into international treaties, he goes back to Congress and pretty much says, hey, we signed this treaty. Now you have to pass these laws or we'll be breaking our international obligations. Congress felt pressured at this point because this happened behind their back, and they passed the DMCA in 1998, which is the exact law that they previously rejected as way too extreme. In October 28th of 1998, Clinton signs the DMCA and the anti-circumvention rules, which become Section 1201. The new law is that the first copyright offense, up to 5 years in prison, $500,000 in fines. Second offense, double that. Section 1201 makes bypassing a digital lock illegal, and a federal crime when you do it for commercial gain, even on something you own. Now, you have to understand when they say commercial gain what they mean here. A John Deere tractor has certain digital locks on it that keep you from being able to fix what you bought and paid for. If I come out with a piece of software that allows you, the owner of the tractor, to be able to service and work on your tractor, if I charge you $15 for that software, I have made a commercial gain off of helping you pick a digital lock, aka 3 to 5 years in federal prison for me. Now, I know what you may say. Well, Lewis, the 3 to 5 years in federal prison is only if they sell it. Okay, how do you have a job? How do you make money? Mechanics, plumbers, software engineers, all the people that allow society to function, the people that maintain society, they do that by charging money for their products and services. I pay my plumber when he comes by because my pipes are fucked up. I pay my electrician when there's something wrong. And I would pay the people that make the software and the hardware tools that allow me to fix an $800,000 combine. If those people are not able to make any money, if it is literally illegal for them to profit from the creation of those tools, they're going to find other jobs. And there are people that have the talent to be able to do this work are not going to do this work. That's why there are farmers in rural Nebraska that are using software that is cracked in Ukraine in order to fix tractors that they bought that were made in the United States. And this is very harmful to the economy because you have all these people that would actually be excited about reverse engineering and doing this work necessary to make devices work again, but they're legally not allowed to do so. It is literally criminalized. A few examples of how this piece of shit law has affected people over the past 30 years. In July 2001, Dmitry Sklyarov was a 27-year-old Russian programmer working for Elcomsoft who went to Las Vegas to speak at DEF CON about weaknesses in Adobe's ebook security. He was arrested by the FBI on July 16, 2001, and was the first person ever criminally charged under the DMCA. He was held in jail for 3 weeks and then released on bail of $50,000 on the condition that he remained in Northern California. The charges against him were eventually dropped, and in 2002, a jury acquitted Elcomsoft on all counts because prosecutors couldn't prove anyone broke the law willfully. So he was trying to show you, here's how you can get around an ebook lock, and he was speaking at a convention about this, and because of that, he got put in prison for several weeks and put on trial. John Deere has told the government that farmers don't own their tractors. In 2015, in its own words to the Copyright Office, a vehicle owner does not acquire copyrights for software in the vehicle and cannot properly be considered an owner of the vehicle software. The Copyright Office granted a repair exemption anyway, over Deere's objection, and Deere responded by immediately rewriting its end-user license agreement. The end-user license agreement uses copyright law and DMCA anti-circumvention language to prevent farmers from accessing, modifying, or reverse engineering the software running their own tractors, which effectively locks them out of independent repair, since most repairs of modern equipment require interacting with that software. In January 2025, the FTC, joined by 2 attorney state generals, Illinois and Minnesota, sued Deere over repair restrictions, and a separate private class action ended in a $99 million settlement that received preliminary court approval in May of 2026. Section 1201 of the DMCA affects literally everything at this point. And the part that I find the most funny about this is when he talks about how the people that were pushing for this law, the people in the music and movie industry, the record label executives, they're literally the last people that you would ever want making this type of law. To paraphrase Bruce Lehman, they're a bunch of junkies that have no place being let near the legislative branch of government because they're not going to be good at coming up with new business models, and they're, more importantly, they're not people that should be fit to regulate and lock down the use of technology worldwide. I remember I got tired of my dad bothering me every single time he wanted something, so I showed him how to use Usenet. He is in his late 70s at this point, and he is able to get a 4K copy of any of the Blu-rays on this desk, uncompressed off of Usenet or SoulSeek or something in less than 90 seconds. This law did not work, but what it did do 30 years later is lay the groundwork for enshittification. It allows companies to create products like thermostats. Thermostats. Try to charge you a yearly fee for being able to make the thermostat work the way it did before they updated the thermostat, and then have the audacity to say that I'm a criminal for trying to get people back access to their fucking thermostat. Breaking a digital lock on something you own should not be a blanket 5-year prison sentence. If that door was locked when I bought my house, after I spend all this good money on this house, I have the right, because I own the house, to be able to keep the locks, to have a locksmith change the locks, to take a screwdriver and a hammer or a fucking bulldozer and just go right through the door. It's my house. I have the right to do that. This law didn't work 30 years ago. The architect of this law admitted that it didn't work 19 years ago, and it's not working today. What we're trying to do here at FULU is try and reform this law, because this law does need a lot of reform, in the words of the person who made it.
Unfortunately, our policies haven't worked out too well. Hopefully there's not any, I won't be quoted in the U.S., but I'm afraid our Clinton administration policies didn't work out very well.
We're going to be doing a lot of work this year and a lot of work next year to try to make that happen. Not just by raising awareness through our bounty program, not just through raising awareness of all the different products that you don't own when you bought and paid for them thanks to it via the Consumer Rights Wiki, but by pushing for real legislation that takes the worst parts of this law and blunts them or crosses them out entirely. If you want to learn more as we go, you can sign up for our newsletter down below. We are also working behind the scenes on a regular basis with legislators to try and work on reform of this horrible law. What can we do to try and take the worst parts of the DMCA and get rid of them? The parts that the architect of the DMCA himself admit did not work and literally reduce the respect of copyright around the world. This is a clip that I play at the end of many of my videos from a gentleman, Devlin Hartline. He's saying, "It is in fact the manufacturers that have the relevant rights, not consumers."
We also have the duty not to infringe the IP rights in the process. It is in fact the manufacturers who have the relevant rights, not consumers.
For all of you who've wondered what the context of that clip is, it's this law. He's speaking at a DMCA Section 1201 triennial hearing process. This is a hearing whereby normal citizens go to the Library of Congress and say, "Please, Mr. and Mrs. Library of Congress, can you please make an exemption for my use case so I won't go to federal prison for using aftermarket ink in my printer? Please." And it's his job to show up to this hearing and say, "No, I don't think people should be able to fix their stuff if they're breaking the DMCA without going to prison." This law existing is what gives this man power. When you reform this law, you take away his power. You return rights of ownership to consumers, not manufacturers. Manufacturers will no longer be the person who gets to decide what you can do with your ball or your pencil or your jacket. When there are actionable things to do, when there are bills on the books, when I need you to contact your congressman or your senator, rest assured, we'll let you know via the newsletter, this channel, and everything else. That's it for today. And as always, I hope you learned something. I'll see you in the next video. Bye now.